that has a conditional claim, because what happens in business? When a company gets successful, people will come out of the woodwork with claims against you. And if somebody can say, well, here's a bill from 2 years ago that never got paid, so I'm going to go after you in court to own your IP. No investor, no inquirer, no strategic partner is going to want to be involved in that. So make sure that you have 100% of the IP that is unconditionally owned by the company. The second thing is you also want to make sure that all of your contracts, either with your employees or with contractors, do have explicit IP disposition terms. There's a lot of misconceptions that if you hire somebody to work for you, that automatically anything they produce is owned by the company. That is not entirely true. It is definitely not true in the case of a 1099 contractor, okay? Because there, explicit case law says, and again, I'm not a lawyer, but I happen to have read a lot of case law, that the contractor owns it until there is a transfer or adherence agreement of some kind. So you want to make sure that if it's a contractor or an employee, you do, and this is one of the perfect examples of what lawyers like to call a belt and suspenders approach. You want to say that the intellectual property is owned and vested in the company, and the person explicitly and fully transfers it, okay? So you own it, but anything you might claim we don't already own, you're going to transfer to us. So that's a belt and suspenders approach, and I highly recommend it. The next thing that we want to get to, assuming that you're all flowing now and you're producing IP, is to think in terms of the 4 kinds of IP so you understand what intellectual capital you want to formalize as IP. What do I mean by that? All of the smarts that go into building your product, your underlying technology, and your company's operation is intellectual capital, okay? And you see it represented in that diagram in the bottom left corner. All of that capital is churning around because you're doing stuff, you're producing stuff. But you have the option of formalizing your intellectual capital in one of 4 different ways. Patents is one of them, copyrights, trademarks, and trade secrets. And we're going to make sure that you understand and can distinguish each of those 4. Everybody in here knows something about a patent, but there may be some things you don't know. First of all, you don't have a right to produce or do anything with a patent. You only have the right to exclude others from doing it, okay? And patents provide stacked rights. In other words, if everybody knows that there's a 3-legged stool that exists, and I'm the first person to come up with a 4-legged stool, my invention of that 4th leg is incremental to the 3-legged stool. I may be able to get a patent on a 4-legged stool after citing the prior art of the 3-legged stool, but does that mean that I can just go out and manufacture and sell 4-legged stools? No. If somebody has a patent on the 3-legged stool, I'm probably going to have to pay them some money. That's a very simplified example relative to the sophisticated technologies y'all are talking about, but it does apply. You are granted a patent by the federal government, but does anybody think the federal government is then going to enforce or protect that patent for you? No. Patent litigation, also known as infringement litigation, is civil litigation, which means the patent holder is responsible for the litigation and the cost thereof, all right? So, when we get into the strategy for do I want to get a patent, it was interesting. That topic was presented yesterday at the IP session. And the patent attorney naturally said, well, if you're going to sell a product, of course you should have a patent. But there are value considerations to be considered. And I like to talk first of all about the 3 different patent strategies based on what you want to do with it. If all you want to do is get a patent so you can be proud of hanging the thing hanging on the wall with the blue seal and all that fancy lettering, then don't spend a lot of money on it. Read up on the online and go file it yourself, what's called pro se filing, okay? If what you want to do is basically have some sort of defensive patent that you can wave in somebody's face if they're sort of trying to pressure you into some sort of a deal, then you might want to get a patent by going to a patent attorney, but you don't necessarily want to spend a lot of money, so don't necessarily go to a top-tier firm. If, however, you are really convinced that what you want to do is use a patent to fence off your yard, your operating area, and you plan to enforce it, you've got to know that you're going to be up against some very highly skilled, very knowledgeable, very wealthy opponents. And so you better go to a top-tier firm that not only has a lot of credentials in patenting and litigation and everything else, but you want to make sure you go to a patent attorney whose field of practice matches what you're doing. Because every patent attorney doesn't just have a law degree, they've got an underlying science or engineering degree. And that's really important, because when you get into claims drafting, you want somebody to have first-hand, not second-hand knowledge of the subject matter that they're discussing with you, okay? So, you know, if for electronics, you obviously want to go to probably somebody that's a double E and has worked even in the subspecialties sometimes. Some of the people that are patent attorneys with the double E deal exclusively in communications. Others will deal exclusively in software. Okay, others will deal in transmission. So, you know, you may find that you want to talk to even somebody with a subspecialty that's very close to yours. When it comes to the life sciences, it becomes a little murky, because there are some major divisions between things like microbiology. Gene patents are certainly very specialized. And sometimes it gets into biochemistry and medicine and everything else. So again, find a patent attorney that really knows your subject matter, and it can make a difference of whether or not you spend $20 million on getting a patent and enforcing it and winning, or you spend $20 million and lose. Okay? So, those are the three things you want to do when you're picking whether or not you want to get a patent and what kind of patent attorney to go for. Another little thing about the litigation. There's three parts to infringement litigation that you want to be aware of as you're thinking about your disclosure. When somebody sues for patent infringement, the first thing that gets argued in court is whether or not the patent that's the subject in suit is valid. So you're going to go back and re-examine all the technology, certainly the prior art, because they'll try and find some obscure prior art that invalidates your patent. They may argue non-patentability of subject matter, which certainly happens a lot with software and business method patents. After you get through the validity of the patent, then you go into infringement. Now that the patent is recognized as infringed, or that it's valid, now do we really have a case that the plaintiff's patent or the plaintiff's practices actually infringe the patent? After you get through that, and both validity and infringement have been stipulated, then you go into damages, and that's pretty complex as well. But that's what you need to think about in terms of making that initial decision. What am I going to do with the patent? Because it is very, very expensive. Your field of endeavor also impacts the expense of both filing for the patent and prosecuting it. Prosecuting in this case is not a criminal matter, but it's the process of the debate that goes on between your filing and when the patent is issued. And in the prosecution, if it's what we refer to as a patent-dense field, processors, incredibly patent-dense. So you're going to pay more for all the prior art searches that have to be done, all the cross-claims analysis and everything, and certainly the litigation is going to be more expensive. Similarly, as we said, when you're talking about life science, you have 3 or more entire sciences to deal with. And so you're going to have a lot of different experts involved, making both the prosecution and the litigation more expensive. What else do I want to say about prosecution, litigation? Prosecution. A couple of little tidbits about the prosecution. When we had that first Mass Challenge gathering over at the Norris Conference Center, I was walking around talking to people and naturally asking about their IP. 4 people told me that they had provisional patents. Anybody know what the problem is with that?
You want a non-provisional?
There's no such thing as a provisional patent. There's a provisional application, which gives you no protection whatsoever. All it does is establish a priority date, which is useful because we have a first-to-file system in the United States. It used to be a first-to-invent system where people could say, well, they both filed today, but this other person can say, I can prove that I invented this 6 months ago, okay? But now that we have a first-to-file, it's really important to get that priority date with your provisional application, which doesn't really have all the claims, and it's a good way to put a stake in the ground, and it establishes, here's another bit of a word of art, the 4 squares or 4 corners of your invention. So you want to broadly discuss the subject matter and the inventive step that you think you've come up with, but you don't have to get into all of the detailed claims drafting, which is the pure art of the patent attorney. Once you file that provisional application, you have 1 year to file a non-provisional application. And that is the point at which you can start saying we have patent pending, okay? The next point in the chain is first office action. That's when the patent office communicates with your patent attorney and says, this is ridiculous, you didn't see this and this and this, go away, or, well, this is pretty good, but you need to change these 15 things, and so forth. So it's an ongoing dialogue or debate between the USPTO and your patent attorney, and that's when they certainly do earn their pay. At some point during the process, you are probably continuing to invent, and you're probably still producing a product, and you may start saying, okay, I want to file another patent that's related, okay? You can build a family of patents out of the original provisional by going in slightly different directions and adding more specificity.
Do you have any suggestions on minimizing back and forth time between the company and the attorneys to try to minimize the cost associated with filing patents?
Yeah, part of it is this conversation right here. The more you know about the broad spectrum and don't go and try and get the same kind of information at $600 an hour,
Yeah.
I think the happier you'll be. Oh, I should also put out the disclaimer. I'm not looking for consulting gigs. I'm fully occupied with my current company.
Yeah.
So this is just, my sort of giving back to the mentoring here. But I will take, in the course of the Mass Challenge exercise here, I have office hours and can certainly exchange email and so forth with you. Yeah, knowledge is certainly helpful, and being one step ahead of where the patent attorney is probably going to take you next. But and that's why I'm covering this kind of subject area. As you continue to develop your invention, there are several directions you might go. As I mentioned, you may file additional patents that precipitate from the original provisional filing, our application, and start building a family of patents. You could also take one patent and do a continuation or a continuation in part, which says, here is more information along the same sort of dimension as what we were first talking about. And those can add claims to strengthen the enforceability and that yard that you fenced off that you're trying to protect other people from doing. Okay? So those are just parts of the patent attorney's art that you'll need to keep in mind, because what you don't want to do is have the patent prosecution get way divergent from what you're really doing with your own technology and product and invention, okay? You want to keep that patent attorney in the loop on those new developments. Okay, let's get away from patents for a moment and look at the other forms. Copyright, without a doubt, the least expensive kinds of IP formalization you can do. It's applicable to documents, music, recording, software, all kinds of things. A couple of things just to make sure you can keep track of what it's about. Copy is the operative word. So if somebody looks at, let's say, something you created, and they get an idea in their mind, and they go over and recreate either the words or a drawing or something like that, they haven't actually copied you. So copyright does involve an explicit act of reproduction. And that's why you see so much of the literature that's written about copyright infringement and so forth dealing with reproduction. Okay? You register a copyright in order to enforce it. Copyright does exist as soon as you create something that is a creative act of authorship. In other words, you actually create something that wasn't in existence in a reduced to tangible form before. So, if, let's say, here's a good example, a recipe. There's no way you can get copyright enforcement on a recipe. But a cookbook, because it's a compilation, now has the opportunity for some creative endeavor. So a cookbook can be copyrighted. And as I said, those rights and copyright exist from the moment that you create it. Do you have to use a copyright legend, as you see on that diagram I passed out? No, you don't. But it is considered good practice a lot of times when you know that you want to put people on notice. I am claiming this, and something's going to happen. We're going to have a serious conversation if you misuse it, if you copy it, or certainly claim it to be your own. But you can't actually send somebody a lawyer's cease and desist letter or file suit against them unless your copyright item is registered. You do that with the Library of Congress. Starting prices are $38, not thousand, not million, $38. So it's easy to see that that may be well worth it. In your various fields of endeavor, descriptions that are informational in nature, you may want to copyright so that somebody can't go off and start really building your knowledge base independent of you. Trademark is the next thing we're going to talk about. And trademark and copyright are frequently confused when people talk about, well, this thing that I put out there about me, do I copyright it or trademark? Here's a good way to keep it straight. If what is valuable about a copyright is a thing is informational, it's probably a copyright candidate. If it is indicia, if it is used to identify the source of a product and not so much to convey information, then you're more likely looking at a trademark, which is a service, which can be also a service mark. Trademarks identify your brand of product, okay? And you want to definitely, even though trademark filing looks fairly easy, the tough part is picking the product classes. Because obviously you've got Delta Airlines and you've got Delta Faucets. Both of those are registered trademarks, but for different product classes, okay? What's the one thing that Apple cannot sell? Apple, you know, the iPhone folks, what's the one thing they can't sell?
Apples.
Apples, okay? They are barred from using that trademark to sell apples because it is the product itself. A trademark in usage, and this is really important because if you do get a trademark, you've got to use it right, should always be treated as an adjective, not a noun. Some of you may have heard that Kleenex is a brand of tissue, okay? But if you just say, hand me a Kleenex, you're using it as a noun. And if the company does that on a repeated basis, they can lose the right to enforce that trademark against anybody, okay? It gets kind of interesting, but just something to keep in mind. Many other examples of that violation: Xerox for any photocopy. Aspirin used to be a trademark, okay? Heroin, in fact, was a trademark. So, anyway, and by the way, I should have mentioned this from the beginning. If you have any questions as I'm going through this, just feel free to jump in. The last thing we're going to cover in terms of major types of IP formalization is trade secret. And this, again, there's a lot of misinformation and misunderstanding surrounding trade secrets. Operative word is secret. How many of you think if I get an NDA with somebody, I can explain my trade secrets to them? Okay. You may, in the course of time, get an NDA with 500 or 1,000 people where you're telling them some sort of confidential information about your technology, your product, or your business. That's fine. If you really want it to be a trade secret, like the formula for Coke or the 11 secret spices in Kentucky Fried Chicken, okay, or how in the world we calculate validity on a predictive quality measure, those are trade secrets, and you tell no one that doesn't have to really know the secret, okay? In my company, there are things that I and one or two key developers knows and nobody else knows. That can be a trade secret. So what you want to do, if you want to perfect something under a trade secret, one, it is secret and you're never going to disclose it. That contrasts from a patent, because guess what? When you file a patent, you have to publish it. You have to tell everybody exactly how to do the wonderful thing that you do, okay? So you'll want to carefully consider whether or not you want to disclose that. By the way, does anybody have an Android phone charger that they're not using right now? Because I'm about to die.
I think we can use this one.
Oh, thank you so much.
Yes, sir.
I just remembered that when I saw you putting something up. Okay, so those are the big four formalizations of intellectual property. Any questions about those? Did you already know it?
I have a question.
Okay.
So is there a time limit on the copyright registration, like from after you first release the work?
No.
Okay.
Now, there are, in fact, a lot of instances where somebody will make use of this idea that copyright rights exist upon creation of the work, and I think fine, okay? Now, that illustration right there, if you were to put it up on a website or publish it in a magazine article, I will probably go to the Copyright Office, register it, prove to them when I developed it, which is the creation point, okay? And then I'll sue you,
Yeah.
okay?
Okay.
So, does that answer your question though? Okay. The registration, as I said, is the only way that you can actually file suit against somebody, but it does not change the date and of the origin of the work, okay? Okay, we already talked about IP disposition and formation of contracts. How many of you have signed an agreement with your respective companies about what you're doing for the company? You have. Have you?
Not regarding IP, but that's on my to-do list now.
Good. And what's your role? Are you the CEO?
No, I'm not. I'm just a partner.
Okay.
We've got 3 people to counting myself, so we're all doing a lot of things.
Okay, so who's doing all that wonderful biochemistry stuff?
That's Elizabeth, one of my partners.
And is she under an agreement?
With the company? With our
Yeah.
company? No, not yet.
Okay.
It's kind of her baby, so
Okay.
hopefully.
Even principal owners can sometimes have a presumption of ownership of the intellectual property as opposed to the company. And so it's always good to have an explicit, whether it's a partner agreement or participation agreement or something like that, that establishes the relationship, because at some point in time, your company is going to be bigger than the founder or founders individually, okay? And so then it becomes not so much a, we're the company and you guys are something else. Everybody then is a component of the company. And I know this sounds a little silly and trite maybe, but it's really important that you get everybody in the company to understand the company is first, okay? And that applies even to the founders, okay? So they have to start off, because it gets a lot harder when the company starts growing and starts getting wealthy and starts doing great things, to think in terms of, what am I going to get out of this? Everybody's got to put the company first. That's not intellectual property, that's just a little sidebar. Patent strategy. Any questions at all on this stuff? Some of you, I think, walked in with specific questions you wanted to ask, I thought. Yes?
No, I just wanted to hear your take on the whole IP landscape.
Okay. Well, let's take a look at the, okay, here's an interesting little tip. You see there in the sort of ladder-looking thing of the white boxes that says patent, trademark, trade secret, copyright, and then underneath it says trade and public domain. Those are potential vents of your intellectual capital that, if you're really doing proper intellectual property management, you actually put some thought to policies on. Because, again, this intellectual capital, all of the knowledge that becomes commercialized in your company, some of it you're going to just give away. I mean, you're going to have to advertise to a whole bunch of folks, you know, what you're doing, what you're offering, what are the benefits, and so forth. And that is going to be considered public domain, but rather than just it being by accident, you should consciously think about what you're going to take of the collective knowledge of your company and put out there in the public domain. When we're talking about trade, that's a little tighter circle in terms of the information that you will consciously exchange with your trading partners, whether they're suppliers, they're contractors, they're whatever. There you'll want to have a little bit more tight bound than you have in the public domain information, and frequently you will do that sort of stuff under a non-disclosure agreement or non-disclosure terms that might exist in another kind of trade agreement. Procurement. Believe it or not, a lot of people that get into procurement know zero about intellectual property, and licensing becomes a rude awakening for them. But on the other side, even when they're just in the process of acquiring normal products, they will frequently talk to people inside the company and find out what requirements are for something that they need to buy, and then go and leak an incredible amount of intellectual property to the suppliers from whom they're buying. So you do want to have a sort of a handle on the procurement people, and obviously it's going to be a while before y'all have a procurement department per se, but anybody that's out there trying to buy things that you need for the company's operation, you want them to be cognizant of what can and cannot be said to the rest of the world. One thing you may have noticed through all of these mishmash of parts and shapes and arrows and everything is that dotted red circle. That represents what I call the boundary of diligence. And it represents exactly what I'm talking about here, that you need to be thoughtful, and that means forethought, not hindsight, okay, about how you want to control all this information and all of the stuff that not necessarily is already formalized into intellectual property, but is intellectual capital that could be or should be later formalized. Productization is a whole other conversation on its own, Even your service and salespeople need to be aware that the stuff that they're learning from the marketplace may come from non-diligent people. What do you think would happen if one of your salespeople was talking to a competitor at a trade show and that guy had kind of loose lips and started revealing stuff about that other company that he should not? And that information comes into your company and you use it. What do you think the problem in that is?
Trade secret.
It could be a trade secret, it could be just confidential information, but there's all kinds of legal opportunities for them to come after you for raiding, for espionage, for misappropriation of confidential or trade secret information. And
Even
so
though their employee disclosed that information to your sales rep?
if you use it, yep. So your people should be, to some degree, responsible enough, because that argument is going to get very murky,
Yeah.
okay?
Are you
Because their
referring
attorney is
to-
going to come back and say, didn't you tell your sales guy to go out there and needle that guy and get him drunk and get him to disclose stuff? Because that's what their lawyer is going to be
Are
telling
you
that
talking in
guy.
regards to more the trade secrets and patent sides of things? Like what if they tell you some information that's useful in the industry, but it's not necessarily proprietary? Is that just not even considered? Or I'm trying to determine like where's the gray area there?
Broad, and I'm just saying, the gray area will come back to bite you. So, your senior executives in time will understand that if somehow or other the presentation on a next generation processor from Intel happens to cross your desk, you don't really want to be caught with it, okay? And you're right, it is a huge gray area, but, you know, those people that live in gray areas tend to end up behind gray bars. Wow. Okay, non-product licensing. How are we doing on time? What time is it? Oh, almost, well, I have another 15 minutes of bonus time, don't I? All of you are in the process of wildly developing basic technologies, right? Some of it may not surface in your product, or your product may in time pivot, okay? So those patents that you create, or even the trade secrets representing know-how, may be something that you can license to other folks. Specifically, when those other companies have an operation that may be complementary to you or make a good trading partner. Maybe they've got some know-how that you want. So that gets into non-product licensing and something for you to consider. Because, you know, all of you are in very early stages. You don't know what the product direction is going to be for years from now. But it can be a tremendous asset to you if you have that know-how or even patents that you can capitalize on through non-product licensing. Well, I don't want to bore you with a bunch of stuff. I was kind of hoping that y'all would have more, you know, Q&A, but got anything?
You mentioned that patent attorneys are always going to want to charge you to file patents regardless if they'll get issued or not, their view on it. So I'm just curious, how do you determine from the start perspective whether you're a technical, non-technical person to decide is that patent worth pursuing and how much is it worth to the company?
First of all, you know obviously now to ask those questions.
Yeah.
That sometimes is one of the biggest things. If you go in with a presumption that this patent attorney is your buddy, okay, that's a mistake, okay? Again, I don't beat up attorneys at all because I've worked with so many of them, and I've been hired by attorneys many, many times for litigation support and so forth. But an attorney's an attorney. They see through things totally through a legal lens. And yesterday, when we were, I was in here and David Gorski, I think was his name, from Houston, who's a patent attorney. was explaining this thing about, I threw out from the floor this thing about the software firms who will want to conditionally own your IP. And he said, well, if I was the attorney for that software development company, I would certainly tell them to hold on to this stuff, okay? And that's because lawyers always deal in the extremes. Non-lawyer IP people a lot of times will position their head in kind of the middle of the deal. And they use a technique referred to as satisficing. Satisficing says, I'm not going to try and get the maximal good for my side. I'm going to try and get us both to a satisfactory middle ground as quickly and efficiently as possible, okay? And one of the things about that technique is when you're looking at this conditional claim on the IP, to the software company, they may use that term in their contract to say, I'm going to protect the $100,000 of revenue I'm going to get in this year from that client. But what they're getting by having that term in there could ruin that other company. So that is a term that turns on an inequity. And that's why people like me have been hired for negotiation and everything, but I never try and take the extreme side of things. I try and go, what's right in the middle? And
When you talk about being right in the middle, is that from a mediation or arbitration standpoint? Are you deciding for them, or do you hear from both sides of the party?
it depends on the actual role that I have. I have been special master in mediation because I have this wealth of background. I've also been witnesses in trials. And if I am in a mediating role, you're right, I listen to both sides, and then I sort of essentially advise both sides at the same time on how to get to the middle, based on, you know, equity, fairness, history, and a lot of things like that. But when you've done that for a while, it sort of oozes out of everything you do. And I realize if somebody is paying me, you know, to negotiate an agreement for them, well, if I argue every little point and try and get us way over here to this side, yeah, I might be engaged for a longer period of time, but am I really doing what I ought to do? Or should I try and, you know, because I really do believe in satisficing, should I talk to both of them and say, let's come to the middle pretty quickly? Because as you, I'm sure, have famously heard, a great contract is when everybody is a little bit unhappy. Does that answer your question? Okay. Cheryl, you've got some questions.
Yeah, I mean, mine are kind of specific to our situation.
As long as they're not too disclosing, go for
I don't think they are. So the non-product licensing
Yes.
you mentioned, so that is kind of our, like, the strategy we're thinking about just right now is we've already started talking with some large companies about helping us get our technology to market.
Yeah.
And so but we previously had people like a judge for another pitch competition we did asked us about like this like specific defensibility of the patent based on the claims and stuff, which is not something I personally investigated. But so we were a little worried. We don't want to get like steamrolled by the big companies that we have to talk to, and since it's already out there as a patent, like I want to make sure we're protected from that standpoint. Like,
Are you saying you have issued patents?
well, okay, so there's one patent.
Okay, that's issued.
I'm not sure what.
Issued means the bell has rung, you know. The
I think
patent.
it has.
Okay, well, it's important to know that.
Yeah, I should
Do
figure
you,
that out.
do you have a patent number? Have you seen anybody say, we have patent number 7,896,231?
That's right. I need to check into that.
Okay, yeah, that's really important.
But yeah, so I know that the research papers and everything, at least on it, are like
Right.
out there in
Right.
the world. So that's the
Published.
thing.
Okay,
Yeah, so
that's
people-
another timeline thing I should have mentioned. 18 months after you file a non-provisional application, your application is published, and people can read it while it's still going through prosecution. Okay, so that's an important thing to know. And there will be sometimes people will see that and they'll come start talking to you about doing business. You cannot license a patent until it's issued. Okay? It's illegal, but even more so, I think the more practical matter is that licensee doesn't know for sure it's going to issue. Why should they pay you either for it? Okay? Now, what can happen is you can get into non-patent commercial cooperation agreements, okay? Where you say, I'm going to give you my information and you're going to use it in this very specific way. And at some time, if my patent issues, then we will have executory terms. In other words, this will happen in the future and conditionally. And that way, you can start working together with somebody, get paid for the know-how that you're giving them, and as long as they operate within those strict terms you've given them, okay, you can say, if it issues and you've been a good boy up till now, we'll give you a patent, or sometimes you'll just say, we'll negotiate a patent license, okay? But those cooperation agreements can be very helpful. You just have to word them right, and I'm sure you're going to be dealing with an IP licensing attorney. Remember we talked before about make sure you're dealing with the right specialist? Not all patent attorneys are good licensing attorneys, okay? Many of them think they are, but anyway. Now, but you brought up a very interesting point too that I probably really should have said about non-product licensing. Again, right now, all of y'all are really excited about the technology you're developing and the inventions and the patents and yada, yada, yada. But in many of the industries you're going into, to be a player in the industry is a huge execution hill to climb, okay? And so for a lot of the inventors that I have advised over the years, I say, here's another one of those upfront questions you really need to grapple with. Do you want to build a manufacturing company of your own? Or do you want to go to Arctic or Caterpillar or IBM or something and say, here's my patent, pay me, I'm going to be a sit-back licensor and take that check every month and y'all go do all that good stuff, okay? That can be a very important decision, particularly to a solo inventor. Some of you, whether it's you as the founders or the founders of your companies, probably are inclined toward building a company, but you're going to find out building a company is tough. It is really tough.
I think our team personally is inclined to something closer to just, kind of pushing it.
Sit
to
back
somebody
license.
who can, somebody who can make it happen. And has
That's
all
cool.
the team in place and everything.
You will probably still have to operationalize to some degree to prove concept, maybe do prototypes and that sort of stuff.
Yeah.
But if that's the case, that's a lot easier road to go, but still, you need to have the right expertise involved to get through that sort of thing and pick the optimal licensee. Pick a field and the leader. Intel, would you say, is pretty much leader in your area?
No, not ours. I mean, they're general purpose microprocessors. So
Okay, but I mean, in terms of the whole thing of processing.
No, NVIDIA right now.
Okay, that's fine. So y'all are somewhat specialized. Sometimes when you're thinking that you're going to take your invention and be a sit-back licensor, your inclination might be, I'm going to go to the market leader and offer to license my patent to them, okay? Here's what you're up against. The market leader knows that they're a market leader, okay? That means they're pretty proud of what they've done, and they are less proud of what you have, okay? So they're not going to give you the best price. They might, in fact, do what some people consider a despicable practice and license your technology exclusively only to bury it. Because your technology may disrupt their vast operation and their technology and their product stance and strategy and approach and everything else. So they want to kill you, okay? It would be better to consider going to the second or third place guy who's hungry. They're looking for something to knock off the market leader.
So my question would go to Intel because they're not the leaders.
Okay, well there you go.
So then they're hungry.
How about when, looking at contract manufacturing and there's both patents and trade secrets involved, but, we're discussing building manufacturing facilities, not something we're trying to be doing.
Yeah.
That would be extremely costly for what we're attempting to do. So how do you navigate that minefield, and is it,
Minefield is a very apt analogy, okay? Because it can blow up and kill you.
yeah,
Are you looking at China?
hell no.
Um,
No, actually,
What-
there was some interest from a program called InnoStars. I don't know if you've heard of it, but it's hundreds of Chinese investors, and my business partner is Chinese, and he was the one that said, we're not doing this, they'll steal our
Right.
technology. So,
Good stuff. The administration's recent statements about that are absolutely dead on. We were talking about it in the hall. It is not that all Chinese people are crooks and thieves and so forth. They actually see the world differently, okay? Same thing with India, okay? So I would be very careful, and I would make sure that you go into it without the tiniest little bit of assumption or presumption. You want everything explicit, everything drawn out, and
But how do you protect your trade secrets and proprietary, and these are things that only our, for example, chief technology officer knows from having done this so many times in the lab.
Right.
And now we're looking at
If-
outsourcing the manufacturing process, and he's eerie just to even share the information with these people.
Right. If your outsourced manufacturing is outside the United States and you have patentable technology, you would certainly want your patent to be,
So we file PCTs as well as international protection in Canada, India, and the EU.
but you know that's only the right to then go file.
Yeah.
Okay.
Well, no, so we filed the PCTs, we've also filed the additional filings in Canada,
Yeah.
the EU, and India.
And that's an interesting point. Patent cooperation treaty, I think there's 40 some odd countries, the big, industrialized countries of the world. And when you file, and there's a lot of practice here that gets really picky, because if you file in the United States and wait to file in Europe, you're screwed, because they consider the U.S. filing to have lost your opportunity to file in Europe, okay? So if you're really planning on filing in multiple countries, again, the patent attorney will give you all the landscape around the world, and you may want to file in Europe first and file a PCT and use that to then come in the United States. The PCT, Patent Cooperation Treaty, only establishes that invitation for you to go and do a in-country filing in their intellectual property system, okay? But bear in mind, in each one of those countries, the laws around what is patentable, what the process is, and what the effects are different. But absolutely, if you're going to be using offshore manufacturing in Canada or Vietnam or Brazil, you want to make sure that you've got a patent in those jurisdictions, because if you wave a U.S. patent at you, they're going to laugh at you, okay? So that's one thing. When it comes to trade secrets, only if the trade secret is absolutely necessary to disclose, such as a manufacturing process or something like that, that oftentimes is kept as a trade secret. It's tough. I mean, it gets to where you better have experienced people in placing manufacturing jobs that can take you through the selection of the individual manufacturer, how to vet them as a partner, and as I said, don't assume or presume the tiniest of things, because that will blow up on you.
Yeah.
It's very, very challenging to do that. Right now, some of the best offshoring opportunities to respect your intellectual property are Canada and Ireland. Okay? Good questions, though.
Thank you for your time.
Sure. Anything else? Y'all ready to book?
Well, I've got one more.
Okay.
So,
Thank you.
I'm gonna grab a card. So you were talking about additional patents
Yes.
to create more of a
Family?
density cars or
Right.
family patents. Is that something we should consider? You don't know all that.
I don't know what your invention is, but let me tell you how and why people use those sorts of things. When you build a portfolio, it gives you more negotiating power should you get into the licensing deal or litigation, okay?
So would like
Because-
more than pay for itself in a lot of circumstances?
Oh, I ain't gonna touch that.
Oh, okay.
No,
That's too
you
complicated.
gotta know a ton of specifics
Yeah.
to make that call. But, as an example, I've got 4 patents, okay? Somebody is going to file infringement against me, and I know that the first thing they're going to do, that's why I mentioned this in litigation, when I was talking about litigation, first thing they're gonna try and do is prove that my patent is invalid, okay? That might hurt me in this case, but that could affect my entire market also if this litigation invalidates a patent on which I'm doing business.
Right.
But if I say, well, if you sue me on that one, I'm gonna sue you on these other 3, because we're in the same playground, okay? But I've got these patents, and now your workload just tripled, and your expense.
So it's more of like a matter of like leverage almost.
Absolutely, absolutely. And it also can become very important when you're doing licensing, because many times between the big players, there's no money exchange. It's cross-licensing. So I will license you my 3 patents if you license me on these other 12, and we just do an even exchange. Okay? Continuation in part, as I mentioned, is a way to deepen the strength of a given patent. And that can be very important as the rest of the world is discovering some of the same technologies that you are and doing the same or inventing in the same field. It becomes a race as to who can get to the biggest fence first. And sometimes that the biggest fence or the strongest fence is based on continuations and continuations in part. Is that it? Okay?
That's all my questions.
Okay. Did y'all get cards?